Hello, good afternoon. Welcome to the Edgardo Angara Professorial Chair Lecture of Professor Rommel J. Casis titled Elementary Dilemmas in Philippine Tort Law. Rommel J. Casis received his Master's of Law from Columbia University in 2010. He earned the distinction of being a Harlan Fiske Stone Scholar or a magna cum laude equivalent. As a law student, he was part of the Order of the Purple Feather for all his years in law school. He was in the top 10 of his graduating class and received the Dean's Medal for Academic Excellence, apart from awards for both academic and extracurricular work. Professor Casis began teaching in the UP College of Law in 2005 and became a full-time faculty member in 2008. He has taught the course Torts and Damages in the UP College of Law since 2005 and is the author of four books. Analysis of Philippine Agency Law and Jurisprudence, Analysis of Philippine Partnership and Law and Jurisprudence, and Analysis of Philippine Law and Jurisprudence on Damages, and lastly, Analysis of Law and Jurisprudence on Torts and Quasi-Delicts. Ladies and gentlemen, let's all hear from Professor Casis.
Thank you, Jenna. In case you don't know, Jenna's my research assistant. She's partly responsible for the PowerPoint presentation. All the errors are hers. Just kidding. Thank you for being here. I know I gave you no choice, but I promise to make the hour or so worthwhile with some pizza afterwards. This presentation, this lecture, is specifically designed for students. It's the first time I did a professorial chair where I had my students in mind more than other people attending it. When I was writing the two books, the Torts and the Damages books, I realized that there were areas where I wanted to talk about a little bit more, but I didn't have the materials nor the time to talk about them. So I decided to use the next couple of professorial chair lectures that I do have to talk about those areas where I wish I had more time to write about. So the first one is this one, Elementary Dilemmas in Philippine Tort Law. I know your interest here as a student would be to know the answers to the possible questions I might be asking based on the lecture today. So I hope to reward you later on in the final exams by actually asking questions from this lecture. So don't tell the other classes. So you'll have your edge. Anyway, before proceeding with the substantial discussion, it's important that we understand the topic at hand. As the title suggests, this lecture, as the title of this lecture indicates, we will be discussing elementary dilemmas in Philippine tort law. There are therefore two terms or phrases we must define. First phrase is elementary dilemmas, and the other is Philippine tort law. The meaning of the first phrase depends on the meaning of the second, so let's begin with the latter. When we speak of, Philippine tort law, what is Philippine tort law? By now you should be able to answer that since you've covered it in our discussion. So part of the things that we'll talk about today you already know, part of it is advanced knowledge for you. Well, the answer to this question can be the subject of an entire lecture itself, considering the fact that the status of tort under Philippine civil law is unclear. The word tort itself, as you know, does not appear in the entire civil code because it was rejected by the Code Commission, and yet jurisprudence treats tort as if it is a natural part of our legal system or civil law. There is also the question of whether a quasi-delict is a tort and vice versa. You know by now that jurisprudence has not been consistent. I have discussed this relationship between torts and quasi-delicts elsewhere, meaning my book, and there is no reason to discuss it now. Just go read that part. But for purpose of moving this discussion forward, let's sidestep the issue of definition of what Philippine tort law is and adopt Carpio's model, which you also discussed in class. Wherein Philippine tort law consists of three main parts: intentional torts, negligent torts or quasi-delicts, and strict liability torts. These three are all found in the civil code. So why is it difficult, or why is Philippine tort law difficult if not impossible to define? Well, this brings us to the second phrase that we need to define, which is elementary dilemmas. The word elementary refers to something basic, and a dilemma is a problem. When we speak of elementary dilemmas, we are referring to basic problems. The fact that a problem is a basic problem does not mean that it's easy to solve. In fact, it may be argued that when it comes to Philippine tort law, the most basic problems can be the most difficult to solve. Basic problems are foundational problems. As I mentioned sometimes in class, torts is like love, it's difficult to define. And just like many other basic principles that you need to know about. Now, what are the basic problems of Philippine tort law? The basic problem is that jurisprudence has been chronically inconsistent in dealing what it calls tort. If common law has a problem in defining tort, it is no surprise that the Philippines will also have the same problem. Because jurisprudence has chosen to adopt the common law concept despite the rejection of the term in the Civil Code. Now, this dilemma is further aggravated. Teka, papos lang ako. Okay. This dilemma is further aggravated by the other use of the term elementary in this lecture. Often, in determining whether a valid cause of action exists, jurisprudence would identify elements that the claimant must comply with. The problem is, in establishing these elements, issues have arisen which would not have arisen had the court just stuck to the language of the Civil Code. This is particularly true in the case of quasi-delict. So the purpose of this lecture is to bring to light these elementary dilemmas in the hope that a solution can be identified. If these are the foundational issues in tort law, then they have to be addressed and not sidestepped, the way that the court sometimes does and commentaries on tort law always does. They always do. But through what I call jurisprudential apologetics, there may be a way to reconcile divergent decisions. If you're not familiar with the term, apologetics means a form of defense or defending a doctrine if you're talking about it in theological terms. So jurisprudential apologetics is like defending judicial decisions by pointing out how they can be reconciled. Unfortunately, not all cases can be reconciled. So defining quasi-delict, this we just talked about. What is the definition of a quasi-delict? Maybe I should call people for recitation. But as you know, Article 2176 says, whoever by act or omission causes damage to another, there being fault or negligence is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contract or contractual relationship between the parties, is called a quasi-delict and is governed by the provisions of this chapter. Now, based on the text, if you're going to simply look at the text of the article, what is a quasi-delict? Is it the act or omission, or is it the fault or negligence? In the first sentence, the act or omission causes the damage. It is this act or omission causing damage which gives rise to the obligation to pay damages. It is therefore reasonable to suppose that this is the quasi-delict. However, in the second sentence, it is said that it is this fault or negligence which is called the quasi-delict when there is no pre-existing contractual relationship. Article 1902 of the Old Code is clearer. It says, any person who, by an act or omission, causes damage to another by his fault or negligence shall be liable for the damage done. Now, assuming that the subtle change in the language in the new code was not intended to change the substance of the text, Article 2176 can be interpreted to mean that fault or negligence is the manner by which the act or omission causing damage to another was committed. It may be said that the quasi-delict is the negligent act or omission. But what about the term fault? Is the concept of fault different from negligence? Now that question brings us to the problem of scope. This is an intermission to keep you interested. If you get the joke, that means law school has not completely destroyed your sense of humor. But if you don't get it, well, law school has done its damage. Now, as for the scope of a quasi-delict, it is clear that the acts committed with negligence can be a quasi-delict, but can an intentional act be considered a quasi-delict? Does fault or negligence in Article 2176 justify the inclusion of intentional acts? Well, if you look at fault or negligence under 1902, the same terminology appears in the Old Code. In a case decided under 1902, Dewo versus La Corporacion, which strangely enough is still assigned in certain or discussed in certain commentaries. Why should you? Because it's decided under 1902. But anyway, Article 1902 of the Civil Code declares that any person who by an act or omission characterized by fault or negligence causes damage to another shall be liable for damage so done. Ignoring so much of this article as relates to liability for negligence, we take the rule to be that a person is liable for damage done to another by any culpable act. By culpable act, we mean any act which is blameworthy when judged by accepted legal standards. The idea thus expressed is undoubtedly broad enough to include any rational conception of liability for the tortious acts likely to be developed in any society. So, the interpretation given to 1902, fault or negligence, refers to any culpable act. That seems to cover any act, perhaps even intentional acts. What is meant by culpable act under 1902? Well, Tolentino, and we always believe Tolentino, interprets 1902 in this way. The obligations spoken of in this article are those which arise from injury caused by an act or omission without malicious intention. The obligations so dealt with differ from those arising from crimes in that the latter are the offspring of illicit acts which are purely voluntary, while the former proceed from acts or omissions not punishable and sometimes involuntary or even not personal to the person who becomes responsible. In Tolentino's view, therefore, 1902 covered acts without malicious intention. In view of this, or in his view, it covered voluntary and involuntary acts provided that these acts were not punishable or were not crimes. Thus, under this interpretation, the act or omission which constitutes culpa quiliana under Article 1902 cannot be a crime, which would be correct, as we discussed today in Barredo versus Garcia. That's how the text of the Civil Code then provided for culpa quiliana. Now, while Tolentino's opinion was supported by the text of the old Civil Code after the ruling of the court in Barredo versus Garcia, which reinterpreted the rule in 1902, the act or omission constituting a culpa quiliana now could be a crime. But the Barredo ruling does not necessarily answer the question of whether a culpa quiliana can be an intentional criminal act. The court in that case, after a thorough discussion of the authorities, I'm sure you read the case in the original, so you're very well aware of all of these authorities. Specifically, they show that there is a distinction between civil liability arising from criminal negligence, governed by the Penal Code, and the responsibility for fault or negligence under Articles 1902 to 1910 of the Civil Code, and that the same negligent act may produce either a civil liability arising from a crime under the Penal Code or a separate responsibility for fault or negligence under Articles 1902 to 1910 of the Civil Code. Thus, the rule stated in Barredo was that the same negligent act may produce either a civil liability arising from a crime under the Penal Code or a separate responsibility for fault or negligence under Articles 1902 to 1910. Under this case, the kind of act that can be both a crime and a culpa quiliana was a negligent act. Therefore, Barredo cannot be the basis for a rule stating that the same intentional act can be a crime and culpa quiliana. Now, voluntary does not mean intentional. Kagiwa, and I'm not referring to Mark, not basketball fans, you don't get it. Anyway, in explaining for, you're not Ginebra fans, or you're too young to know who he is. In explaining what a quasi-delict is, says that it is different from Anglo-American tort because it does not include intentional offenses. Although the concept under the new Civil Code includes acts or omissions punished by criminal law, it differs from dolo or fraud, and there is no deliberate intent to break the obligation or cause damage to another, but merely carelessness or want of due care required by the circumstances. According to Harencio, also not Bido, kilala niya now as coach, but he used to be a player too. In discussing Article 2176 explains, fault in general signifies a voluntary act or omission which causes damage to the right of another, giving rise to an obligation on the part of the actor to repair such damage. But fault in civil law must be distinguished from dolo. If the act or omission causing the damage is committed with intent to cause damage, it is dolo. The act becomes a crime and is governed by the revised penal code. When intent is absent, it is fault or culpa. The distinction between the two concepts depends on the will of the actor rather than on his intelligence. The statements of Kagiwa and Harencio underscore the clarification made earlier regarding the ruling in Barredo. The fact that a quasi-delict may be a criminal act does not necessarily mean that all criminal acts may be a quasi-delict. An act cannot be a quasi-delict if there is a deliberate intent to harm. Only crimes, therefore, only crimes committed with criminal negligence can be a quasi-delict, but not crimes committed with deliberate intent to harm. Do you get the joke? So is it worth it? Can I have a show of hands? Those who think that passing your law school finals is worth your lack of social life for the past 5 months? No show of hands, so I guess not worth it. Okay, those a few. Si Aline lang ata. Okay. The problem, however, maliwanag. The code is clear, the commentaries are clear. Unfortunately, the court is sometimes not clear. In Elcano versus Hill, the court held that Article 2176, when it refers to fault or negligence, covers not only acts not punishable by law, but also acts criminal in character, whether intentional and voluntary or negligent. However, as it has been explained in detail elsewhere, Elcano cannot be used as basis for saying that a quasi-delict can be a criminal act with intent to harm. Now, neither is the statement in Andamo versus IAC, which copies the same statement in Elcano without quoting it as a source. It's actually quoting Elcano. A proper legal basis because it's obiter dictum. How do you know that? I've discussed that elsewhere. Unfortunately, both Elcano and Andamo were relied upon by the court in Dulay versus CA, where it said that there is no justification for limiting the scope of Article 2176 of the Civil Code to acts or omissions resulting from negligence. Well entrenched is the doctrine that Article 2176 covers not only acts committed with negligence but also acts which are voluntary and intentional. The respondent in this case, I think, was smarter than most because he argued that the word intentional, or at least his lawyer was, he argued that the word intentional in Andamo was an inaccurate obiter and should be read as voluntary because intent cannot be coupled with negligence as defined by Article 365 of the Revised Penal Code. Unfortunately, the court did not listen to him. The court dismissed this argument, saying that in the absence of more substantial reasons, this court will not disturb the above doctrine on the coverage of Article 2176. Well, that's what I just said, and that's what the court said. But I think that with all due respect to the court, a jurisprudential misreading of a clear provision in the Civil Code is a substantial error. What do you think? And must be corrected. If the rule stated in both Elcano and Andamo is not authoritative, then the reliance of on these two cases on Dulay makes the rule stated therein also not authoritative. Otherwise, obiter dicta cited in earlier cases will become doctrine by quoting it in later cases. In other words, lies repeated often enough become the truth. But there is a compelling argument for the rule that 2176 or quasi-delicts include intentional acts. It can be made, this compelling argument can be made when in cases involving vicarious liability. This we will study towards the latter end of the course. Under Article 2180, a person may be held liable for a quasi-delict for acts committed by a person for whom he is responsible for. Parents, children, teachers, pupils, employers, employees, and so on. State for a special agent. The argument is that it should not matter if the injury caused by the act or omission was committed with intent to harm. The logic of the argument is that if under Article 2180 a person can be held liable by the mere negligence of a person he is responsible for, should he not also be responsible for the intentional acts of that same person? For instance, under Article 2180, an employer is liable for the damage caused by an employee for acts or omissions within the scope of his assigned tasks. Jurisprudence explains that under this article, if an employee is found negligent, the employer is presumed negligent in the selection and supervision of his employee. So if you were to go and eat at McDonald's and the staff or the employee there were to give you something that caused you to have a stomach ache, there is a presumption that the company, McDonald's, is liable for the acts of its employee if the employee was found to be negligent. Shouldn't McDonald's be also held liable if the employee did it deliberately, putting some noxious substance in your food? Shouldn't McDonald's also be liable under that situation? So the argument is that if the employer is liable for mere acts of negligence of an employee, shouldn't he also be held responsible for acts with intent to harm? My answer to that is not necessarily, but that's the argument being made under this compelling argument. Again, if you don't think it's funny, you can blame her. Just kidding. By the way, Jenna was one of the best students in my class. She had, what was your grade? 275? I see. Anyway, kinakot na, no? The answer to this argument would require a closer scrutiny of Article 2180. The first paragraph of Article 2180 states that the obligation imposed by Article 2176 is demandable not only for one's own acts or omissions, but also for those for whom one is responsible. The obligation referred to is the obligation to pay damages. Therefore, the article is saying that a person is responsible to pay for damages not only for his fault or negligence, but also for the fault or negligence of those he's responsible for. The article goes on to list the persons vicariously liable and the persons for whom they are responsible. The article ends saying that the responsibility treated of in this article shall cease when the persons herein mentioned prove that they observed all the diligence of a good father of a family to prevent damage. The persons herein mentioned refers to the persons vicariously responsible and not the actors. So let me clarify. The actor is the person who directly caused the damage, the negligent actor. The person vicariously responsible is the person responsible for that actor which caused the damage. Therefore, the text of the article suggests that the quasi-delict is the negligent act or omission of the person vicariously responsible. So you have two actors. The text can suggest that the quasi-delict is actually the negligence of the person vicariously responsible and not the actor. In other words, the person who is guilty of the negligent act is the person vicariously responsible and not the actor. This interpretation of Article 2180 would be supported by the cases wherein a person was held vicariously responsible or liable for the intentional acts or omissions of a person for whom he is responsible for. So, it's still negligence because even if intentional yung act ng actor, there's still negligence on the part of the person vicariously responsible. This interpretation, while supportive of the compelling argument made earlier, raises some questions. First, if the person vicariously responsible, the parent, the state, the employer, is liable for all the acts or omissions of the actor, the child, the pupil, the special agent, whether negligent or with intent to harm, why does the court require a finding of negligence on the part of the actor in many cases? In fact, before applying Article 2180, if it doesn't matter whether the actor, the child, the special agent, the employee acted with negligence or not, because it covers also intentional acts, why does the court bother to investigate whether that actor was negligent? The second question, is that under Article 2180, as you see, there may be two negligent acts. That of the actor, the person causing the injury, and the person vicariously responsible. In the case of an employer, it's his negligence in the selection and supervision of his employee. If the negligence of the latter, that is the person vicariously responsible, is the quasi-delict, shouldn't it be required that such negligence be the proximate cause of the injury before there can be a quasi-delict? Kung yun yung quasi-delict, dapat yun yung dapat na proximate cause. But that doesn't happen in the cases. Why is it that in many cases involving vicarious liability of employers, an employer can be held liable under Article 2180 upon his failure to rebut the presumption of negligence on his part? What generally happens in the cases when you want an employer to be held responsible is that you just prove the negligence of the employee. A presumption of negligence arises on the part of the employer, which he has to rebut. If he does not rebut it, then he is liable. The claimant must prove that his negligence, presumed or otherwise, is the proximate cause of the injury. But we don't see this. It's not enough. There has to be causation connecting the negligence to the injury. But we don't see this in the cases. Although the same complaint can be made against the view that an actor omission of the actor is the quasi-delict. Now, in many cases, after his negligence is proven, there is at times no discussion as to why his negligence is the proximate cause. When we study Article 2180, you will notice that many times the court would simply identify the negligence of the actor, then raise the presumption of negligence on the part of the person vicariously responsible, without discussing why that negligence is the proximate cause, which is a requirement as one of the elements of quasi-delicts. Now, despite these questions, the current state of jurisprudence seems to be that cases based on Article 2180 can prosper even if the actor acted with intent to harm, provided that the person vicariously responsible was negligent. This is a strange setup, considering that the actor is not necessarily committing a quasi-delict if he is not negligent, and neither is the person vicariously responsible because his negligence is not required to be the proximate cause. This is the status quo. But the status quo may be acceptable to many because it allows for recovery despite conceptual inconsistency. Or maybe Article 2180 is a special kind of quasi-delict, not requiring the three elements. Now, the distinction between fault and negligence. Harencio differentiates fault from negligence in this way. Liability under Article 2176 may arise either from fault or negligence. In other words, liability may be incurred by an act or through an omission. Fault requires the execution of a positive act, which causes damage to another, while negligence consists in the omission to do acts, which also result in damage to another. The actor omission must be without intent to cause damage, because if there is intent to cause damage, the actor omission becomes a crime, and civil liability for such actor omission will be governed by the revised penal code. So in Harencio's view, fault corresponds to acts, while negligence corresponds to omissions. Now, whether or not it's an act or omission, it's still a failure to comply with the standard of diligence required of a person. This view, Harencio, remember, wrote this book some time ago. This view was accepted, or appears to have been accepted, in a case decided by the Court, Child Learning Center versus Tagarino, where the court said fault in general signifies a voluntary act or omission which causes damage to another, giving rise to an obligation on the part of the actor to repair such damage. Negligence is the failure to observe for the protection of the interest of another person that degree of care, precaution, and vigilance which the circumstances justly demand. Fault requires the execution of a positive act which causes damage to another, while the negligence consists of the omission to do acts which result to damage to another. So the court has adopted Harencio's view. Harencio further explains that there are two kinds of fault. Fault substantive and independent, which you've seen in the cases, which on account of its origin gives rise to an obligation between two persons not similarly bound by any other obligation or contract. And fault as an incident in the performance of an obligation, which is in culpa contractual, if you remember. Okay. What is involved, of course, is the, as to which type of, as referred to in Article 2176, he says, it is the fault substantive and independent, which in itself is a source of obligation. This kind of fault is known as culpa extracontractual or culpa achilleana. Fault as an incident in the performance of a pre-existing contract is known as culpa contractual. Kagiwa adds that he also adds a different categorization between juridical and moral fault. Now, I'm not completely, you can just read it there, I'm not completely in agreement that this particular moral fault is not actionable in any way. But this is another way to distinguish fault. The term fault or negligence also appears in Article 1173, another article which you will know by heart before this semester ends. It says that the fault or negligence of the obliger consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. Now, explaining the meaning of fault in this provision, Nicolas writes that the word fault is synonymously used with negligence or culpa, a Latin word which in the civil law means fault, negligence, or neglect. Therefore, it may be said that apart from the difference identified by Herencio and apparently adopted in Child Learning Center, there is no substantial distinction between fault or negligence, and the two terms, fault or negligence, can be subsumed under the general concept of negligence. So fault is negligence. If you want to differentiate, one talks about acts, one talks about omissions, but it's under the same concept as defined under 1173. Elements of a quasi-delict. First, let's look at the elements of a quasi-delict in the Old Code under Article 1902. According to Tolentino, in order to give rise to an action under this article, the following requisites, so these are the elements during their time, that there exists a damage or injury which must be proved by the person claiming recovery, that there exists a wrongful act or omission imputable to the defendant by reason of his fault or negligence, and that there be a direct relation of cause and effect between the damage and the fault or negligence. Looks familiar, seems similar to our three-element rule found in jurisprudence under 2176. In Donaldson versus Smith, the court explained that Article 1902 of the Civil Code established the general principle of liability for damage caused by fault or negligence, and there can be no fault or negligence where there was no obligation resting upon the person causing the damage to exercise diligence as respects the other injured person. In Francisco versus Onrubia, the court explained that it is necessary that the negligence or fault in question be not be punishable by law. Giochino versus Araneta, the court discussed that Article 1902 was not applicable against the defendant because the negligence was not the proximate cause. An example in the Old Code where it was required that the negligence under 1902 be the proximate cause of the injury. In Receiver versus Ibanez, the court explained that the word damage in Article 1902 includes any and all damages that a human being may suffer in any and all the manifestations of his life, physical or material, moral or psychological, mental or spiritual, financial, economic, social, political, and religious. Now, why would this case be useful for us even today? What case are you reminded of after reading this case? Shout it out loud. Wala? For C, we just discussed it this morning. Cinco versus Canonoy talks about how quasi-delicts includes damage to property. Instead of using 2191 number 2, court could have gone into the history of 1902. And actually, if you look at this, you could argue that this is broader in terms of interpreting damage or harm under Article 1902 than Cinco versus Canonoy. Something to think about. Now, what are the elements of quasi-delic under Article 2176? This you should already know by heart. The court has ruled in a number of cases that based on Article 2176, there are three elements necessary to establish a quasi-delic. The damages or damage or injury suffered by the plaintiff, fault or negligence, and the connection of cause and effect. Damages, of course, is wrong. It should be injury. It should not be damage. In other cases like Bulao versus CA and D. Teban versus Jose Ching, the court used damage, but this is also not, well, I've already mentioned that. Now, the fact that there is damage along with two other elements may not be sufficient because of damage or damnum absque injuria. Damage is also is not a correct way of putting the element, because as defined in Custodio versus CA, it should be injury. Now, there is in some cases an additional element. The court would sometimes add, like in, sorry for the size, Gregorio versus CA, the court added a fourth element, that there must be no pre-existing contractual relation between the parties. You know that this could be an element because if you look at 2176, that requirement is there. But I'd like to just focus on Gregorio versus CA, because in Gregorio versus CA, the court added that fourth element, but it cited as its basis Corinthian Guardians versus Tanhanco, which was written by the same ponente. But if you go to that case, you will notice that in Corinthian Guardians, there was only three elements. So where was he wrong? Was he wrong when he wrote Corinthian Guardians? Or was his clerk wrong when his clerk wrote Gregorio versus CA? Anyway. So did you just survive your first year of law school? The fun is just beginning. Now, it didn't define whose fun it is. It didn't necessarily mean that it's fun for the students. It might be fun for the professor, seeing you squirm. Now, this to me is one of the most difficult aspects or questions or elementary dilemma when it comes to quasi-delics. What is the effect of a pre-existing contractual relationship? I don't think we've discussed this yet. This is for next week, so perhaps you should listen closely. Can a quasi-delic exist if there is a pre-existing contract between the parties? First, let's look at the text. You already know what the text provides. It says if there is no pre-existing contractual relation, it's called a quasi-delic. The text of the article suggests that a quasi-delic can only exist if there is no pre-existing contract between the parties. But the use of the phrase "is called" creates ambiguity. The first sentence of Article 2176 creates an obligation on the part of the person who by negligent act or omission caused damage to another. The second sentence says that such negligent act or omission is called a quasi-delic if there is no pre-existing contract between the parties. Why did the code use "is called"? How does the requirement in the second sentence that there is no contract between the parties, how does that requirement affect the obligation to pay for the damage caused by negligent acts or omissions found in the first sentence? Does the existence of a contract between the parties negate the existence of the obligation created under the first sentence? Does the obligation subsist, but you simply can't call it a quasi-delic? What is the purpose of the second sentence in Article 2176? That is the question. One way to answer it would be to say that it's simply a rule on nomenclature. It may be argued that if the purpose of the no contractual relation requirement was to negate the existence of a quasi-delic, then the article should have been written differently. It could have been written as one sentence in this way, by inserting that part in bold, provided there is no pre-existing contractual relation between the parties. And then you just then say such fault is called a quasi-delict. So if you write it this way, well, the fact that no contractual relation requirement was separated from the first obligation or the first sentence, and the use of the phrase is called as opposed to simply saying is, suggests that such requirement does not affect the obligation. If this were the case, the second sentence may be interpreted as simply a rule on nomenclature. It gives a name to the negligent act or omission when there is no pre-existing contract between the parties. This view is also, or rather seems to be supportive by the intent of the Commission. According to the Code Commission report, it says, a question of nomenclature confronted the Commission. After careful deliberation, it was agreed to use the term quasi-delict for those obligations which do not arise from law, contracts, quasi-contracts, or criminal offenses. They are known in Spanish legal treatises as culpa aquiliana, culpa extracontractual, or quasi-delitos. The phrase culpa extracontractual, or its translation extra-contractual fault, was eliminated because it did not exclude quasi-contractual or penal obligation. Aquilian fault might have been selected, but it was thought inadvisable to refer to so ancient a law as the Lex Aquilia, although sometimes Roman law is still discussed in tort classes in the College of Law. So quasi-delicts was chosen, which more clearly corresponds to the Roman law classification of obligations, which is in harmony with the nature of this kind of liability. The Commission also thought of the possibility of adopting the word tort from Anglo-American law, but tort under the system is much broader. And so you look at the discussion of the Code Commission, their problem was a problem of nomenclature. What do we call Article 2176? Thus, the second sentence may simply be the result of this question of nomenclature, which the Commission grappled with. Their intention may have been simply to establish the name as to what was being described under Article 2176. And it was just unfortunate that the text lent itself to an interpretation that the mere existence of a contract prevents a quasi-delict from coming into existence. Thus, under this interpretation, the obligation created under the first paragraph, or rather first sentence of Article 2176, subsists even though a contract between the parties exists. The second sentence only gives a name to that obligation where no contract at all exists. However, as you probably, I'm thinking about it right now, this interpretation, while supported by textual consideration, creates an obvious problem. What is the name of the negligent act or omission causing damage to another when there is a pre-existing contract? If you call it quasi-delict if there is none, so what do you call it if there is? The obligation subsists, but it cannot be called a quasi-delict because that name only applies if there is no pre-existing contract. Thus, the interpretation may be creating a nameless tort. Now, supporters of this argument could argue that it's not a nameless tort because the first sentence of 2176 is substantially the same as Article 1902 of the Old Code. If the latter is referred to as culpa aquiliana, then the first sentence of Article 2176 is also culpa aquiliana. Thus, it's not a nameless tort. The effect of this, however, is that Article 2176 defines two concepts. The first sentence defines a culpa aquiliana, while the second sentence defines quasi-delict. This implies that quasi-delict and culpa aquiliana are two different concepts. What do you do now about all these cases that equate the two concepts? So we'll give rise to more questions. Another way to look at Article 2176 is that it negates the obligation. It may be argued that the text suggests that the second sentence adds a further requirement, a fourth element, to establish a quasi-delict. The second sentence, if you look at it, is referring to the fault or negligence mentioned in the first. so it cannot possibly describe something different from it. In other words, the second sentence is describing what is being referred to in the first sentence. Thus, both sentences are defining the same thing and should be considered one whole idea. Therefore, under this interpretation, a quasi-delict cannot exist if there is a pre-existing contract between the parties. A pre-existing contract between the parties negates the existence of a quasi-delict. This interpretation, this textual interpretation, may also be supported by the intent of the Code Commission. As quoted earlier, the term culpa extracontractual, or its translation extracontractual fault, was considered but eliminated because it did not exclude quasi-contractual or penal obligations. But it is important to note that it was considered because these terms conform to the idea that Article 2176 is supposed to cover non-contractual fault. The Code Commission report also stated that the word tort was rejected because it was much broader than the Spanish-Philippine concept of obligations arising from non-contractual negligence. Hence, therefore, the intent of the framers was to limit Article 2176 to non-contractual negligence. So, any ducks? Ay, hindi ko pala ito. Kala ko it's the duck. It's the tweet joke. Anyway. So, the text and the Code Commission can support the two different arguments. So, we go now to jurisprudence. Considering that the text of the article and the intent of the framers can support two contrasting interpretations, we have no choice. We have to resort to jurisprudence. Unfortunately, as in most of the time, instead of providing clarity, jurisprudence further clouds the issue. In Forrest versus Miranda, the court ruled that an action for breach of contract cannot simultaneously embody an action for tort. This statement is not the same as stating that a quasi-delict cannot exist if there is a contract. However, it can be implied. Nevertheless, the authoritativeness of this implied rule is doubtful, considering the reasoning behind it, which I have discussed elsewhere. And by elsewhere, you know what I mean. In PSBA versus CA, the court made three statements on this issue. Because the circumstance, well, I think we could go to the next slide because we discuss it one at a time. And it should come up. It says, the first statement says that because there is a contract between the parties, the rules on quasi-delict do not really govern. Please do not speak this way in my class. Do not really govern. What does that mean? The rules on quasi-delict can refer to a number of provisions. What kind of rules is the court referring to? Is the court saying that if there is a contractual relation, there can be no quasi-delict? Or only that the rules of quasi-delict, whatever these rules may be, do not apply? It is also not clear what the court means by these rules not really governing. They kinda govern? What does that mean? Do these rules absolutely not apply? Or generally not apply? If it were only stating a general rule, the court did not specify any exceptions to the general rule. After this statement, the court said this. The court points out that based on Article 2176, obligations arising from quasi-delict arise only between parties not otherwise bound by contract. This statement is a categorical rejection of the possibility of a quasi-delict if there is a contract between the parties. This may be taken as a clarification of the weird statement before it, but unfortunately, the court did not stop while it was ahead. It said something else. In its third statement, the court said that the rule in the second statement that you cannot have a quasi-delict if there is a contract as a mere impression, which has not prevented the court from determining the existence of the tort even when there is a contract. It is not clear as to whether this observation negates the rule mentioned in the second sentence. Basically, it contradicted the second sentence. On its face, the third statement casts doubt on the authoritativeness of the rule by citing contrary rulings of the court as basis. But the problem is, can the court's rulings overturn a rule stated in the civil code? Of course not, but it does that all the time. Furthermore, this third statement refers to tort and not to quasi-delict. Then again, the court in the second statement equated tort with quasi-delict, or at least used the terms interchangeably. Finally, after the third statement, the court tried to explain the ruling in Air France versus Carrascoso and interpreted the ruling in Air France versus Carrascoso as authority for the view that liability from tort may exist even if there is a contract, for the act that breaks the contract may also be a tort. Unfortunately, despite its popularity, and Air France is very popular, it's always cited, Air France does not solve the problem at all. As we have explained in detail elsewhere, Air France is not, because of the factual considerations in Air France and the legal considerations in Air France, which one of you will explain during class at some point, it is disqualified from interpreting this problem. Air France does not resolve the issue. So you cannot use Air France as your basis. In Consolidated Bank, the court said, the law on quasi-delict or culpa quiliana is generally applicable when there is no pre-existing contractual relationship between the parties. So, what does this mean? Based on this statement, the law on quasi-delict would apply as a general rule in cases where there is no pre-existing contractual relationship. By stating this rule as a general rule, the court is implying what? That there is an exception. But the court didn't bother to talk about any possible exception. So if there's no exception, is it a general rule or an absolute rule? In this case, the court appeared to have used this general rule as a justification for its application of the rules on culpa contractual and not culpa aquiliana. The court agreed with the trial court that what was involved in this case was a contract between a depositor and a bank. We'll have many cases like that between depositors and banks, thereby rejecting the application of the rules on culpa aquiliana relied upon by the appellate court. Curiously, however, the court went on to discuss at length the proximate cause of the injury. If this were a case for culpa contractual and not culpa aquiliana, there was no reason to determine the proximate cause, because the issue of proximate cause is not relevant as far as culpa contractual is concerned. So in this sense, even in this case, the court did not even apply its own rule. It applied the rule on culpa aquiliana in a case which it identified as a case for culpa contractual. So if a court states a rule but then does not apply it in that same case, or not apply it, it violates it in that same case, how authoritative is that rule? In American Express versus Cordero, the court said that in order that an obligation based on quasi-delict may arise, there must be no pre-existing contractual relation between the parties. But there are exceptions. At least they discuss exceptions. There may be an action for quasi-delict notwithstanding that there is a subsisting contract between the parties. A liability for tort may arise even under the contract where tort is that which breaches the contract. Stated differently, when the act which constitutes a breach of the contract would itself constitute a source of quasi-delictual liability. So in this case, the court considers the non-existence of a contract between the parties to a case for quasi-delict as the general rule. The exception, according to the court, is when tort is that which breaches the contract. That rule can be traced again ultimately back to Air France, which, as I've mentioned, does not provide adequate legal basis. On the other hand, so we discussed cases which seem to suggest you cannot have a quasi-delict if there's a pre-existing contract. On the other hand, there are other cases which Well, where the court appears to rule that a pre-existing contract and a quasi-delic are not mutually exclusive. Therefore, you can have both. For instance, the third most case I hate the most, Sikia versus CA. The court mentioned, this is the one with the floating grave. Anyway, the court mentioned that a pre-existing contractual relation between the parties does not preclude the existence of a culpa quiliana. But the court did not explain or provide a basis for this statement. This case involved a complaint for recovery of damages arising from a breach of contract and or quasi-delic. So the party in that case, the claimant, wanted to use either or, culpa contractual or culpa quiliana, filed by the heirs of a deceased buried in a memorial park of the respondent. The suit was commenced when the heirs discovered that the coffin and the remains of the deceased were damaged by water. The court held that because there was no contract, rather there was a contract between the parties, such agreement governed the relation of the parties and defined their respective rights and obligations. It added that hence, had there been an actual negligence on the part of Manila Memorial Park Cemetery, it would be held liable not for quasi-delic or culpa quiliana, but for culpa contractual. This statement seems to say that because there was a contract between the parties, negligence, if proven, would be considered culpa contractual and not culpa quiliana. The court did not state this in the context of explaining the second sentence of Article 2176, but if it were, the court would be explaining that such sentence is not stating that a pre-existing contract precludes the existence of a quasi-delic, but only creates a rule on priority. What does that mean? If there is a breach of contract committed via negligence, then Article 2176 would require that it be governed by the rules on culpa contractual and not culpa aquiliana. So it's a rule on priority, not a rule on preclusion. 2176 second sentence. In this case, the court did not find any breach of contract. So it went on to determine if there was negligence, which could become the basis of an action for quasi-delic. Back to PSBA versus CA. This statement in Sikia is similar to what the court said in PSBA. Basically, just to cut the long quotation short, in PSBA what was involved was a student was stabbed by outsiders, and PSBA was sued. There was a motion to dismiss. Similar to Sikia, the court here was saying that if there was negligence, that negligence would have to be negligence culpa contractual, because the negligence of the school cannot exist independent of a contract. The court's statement that the negligence of the school cannot exist independent of a contract seems to imply that negligence is only relevant if it exists independent of a contract. What I mean is, it could only be culpa aquiliana if negligence would give rise to an obligation even without a contract. Another case is Far East Bank versus CA. The court has not in the process overlooked another rule that a quasi-delic can be the cause of breaching a contract that might thereby permit the application of applicable principles on tort, even when there is a pre-existing contract between the plaintiff and the defendant. This doctrine, unfortunately, cannot improve private respondent's case, for it can aptly govern only when the act or omission complained would constitute an actionable tort independent of the contract. So in other words, yes, there could be a quasi-delic and a breach, or rather culpa contractual at the same time. But you can only have a culpa aquiliana despite the existence of a culpa contractual if, even without that contract, a culpa aquiliana would be a basis for an action. It has to be an independent obligation. Okay. Furthermore, there are other cases where the court didn't point out, or didn't even bother to point out, that there's no problem with, or there's a problem with having a contract and a quasi-delic in the same time. For instance, in BLTV versus IAC, involving a collision between two buses. The passengers of one bus sued the owners of both buses they were riding on for damages they sustained. In BLTV, the owner of the bus the injured passengers were riding on argued that the action should have been based on culpa contractual. The court responded by saying that a reading of the appellate court's decision showed that it anchored the bus company's liability in culpa contractual and culpa aquiliana, both. So the court found no problem that the bus company was both liable, culpa contractual and culpa aquiliana at the same time. Same thing in PI versus Lifetime. Obviously, there is a contract between a depositor and the bank, but the court ruled on the basis of culpa aquiliana, implying again that there is no problem having both cause of action exist at the same time. In the case of Makati Shangri-La versus Harper, this involved a hotel guest who was killed inside the hotel because the hotel security was unable to prevent a stranger, quote unquote, from coming in and killing him. Why he opened the door for the stranger is another question altogether. The court adopted the ruling of the appellate court, finding that the hotel owner was negligent in providing security measures. 2176, even though there is an obvious contract between the parties. Best bud bugs in town. Okay. How do you now reconcile all of this? We've talked about all the problems, the text, the jurisprudence. So how do we reconcile? Where is the jurisprudential apologetics here? Well, perhaps there is a way to reconcile the text of Article 2176 that preserves the vision of the framers and is consistent with the intent or the intended interpretation of jurisprudence. As discussed, the Code Commission deliberately chose to use the word quasi-delict to convey the exact coverage of the source of obligation defined under Article 2176. The second sentence may be seen as the Commission's attempt to explicitly express this intention to limit the coverage of the action based on Article 2176 to exclude actions similar to Anglo-American tort and or intentional criminal acts. That's why they had a separate sentence just for quasi-delict, just for that statement, to make it clear that our intention is to limit 2176 to actions that are not the same as Anglo-American tort, which would include intentional criminal acts. Remember, the choice of the term quasi-delict, that was its primary consideration. But what of the phrase, if there is no pre-existing contractual relation between the parties? To preserve the vision of the framers, the word if should be understood as where, such that the phrase is not interpreted as a condition, but a description. In essence, the second sentence merely reiterates that the action based on quasi-delict is not based on contractual negligence. Carpio, writing as a student, says this: the second sentence of Article 2176 did not appear in Article 1902 of the Old Code. The provisions govern quasi-delicts under the Old Law. And notwithstanding the addition of the second sentence in Article 2176 of the present Code, the Supreme Court has not changed its view. It has been said that the second sentence was added in the present Code for better clarity without changing the essence of the precept contained in 1902. If that was the purpose, then not only did the second sentence fail miserably, I agree, in its purpose, it also confused the concept of quasi-delict. They had good intentions, there was just something wrong with the execution. Carpio adds that we are disposed to think that the second sentence did not add any requirement to those already recognized under the old law for the existence of a quasi-delict. The second sentence can best be explained as an attempt to distinguish an action based on quasi-delict from one founded on breach of contract, particularly in cases where a quasi-delict is coincident with a breach of contract. An action under Article 2176 may lie, although the relation between the parties, which gives rise to the quasi-delict, emanates from a contract. as when the defendant through negligence violates a legal duty, which arises from when the contract is made, but which legal duty is not identical with the contractual obligation. What does this remind us of? It reminds us of the rule on independence mentioned earlier in the case of Far East Bank and PSBA. Yes, it can be coincident, but the culpa acquisiana must be able to exist independent of the contract. So, as in Far East Bank, which involved a credit card, there cannot be a culpa acquisiana there because without a contract for credit, a bank has no obligation to lend money to a person. Okay? So that's how that rule was applied in that case. Therefore, the mere existence of a contract does not preclude the existence of a quasi-delict. If there was negligence in breaching the contract, it would be considered culpa contractual. But such negligence may also be considered culpa acquisiana if the defendant's duty to be diligent subsists even without a contract. This is my attempt at marrying all the rules that are, or the cases that have been decided surrounding this issue. Okay? Pop quiz. That's good. What did I just say? Okay, now. We now reach the latter part of the lecture. Don't worry, I have around just 14 more slides or so. Despite the rejection of tort under the Civil Code by the Code Commission, it has not stopped the court. I guess it's very difficult to stop the court. Just ask Pinoy. It has not stopped the court from citing 2176 as a basis for actions which appear to be based on tort. It still uses 2176 for tort. An example, as we briefly discussed already in class, are cases involving medical negligence. In Cayaw Lasam versus Spouses Ramolete, the court characterized the case as a medical malpractice case, which it defines this way. It is often brought as a civil action for damages under Article 2176. Earlier, the court also said that medical malpractice is a form of negligence when consists in that failure of physician or surgeon to apply to his practice of medicine that degree of care skill which is ordinarily employed by the profession generally under similar conditions. So it defined medical malpractice. As to the elements of medical negligence, the court said there are 4 elements: duty, breach, injury, and proximate causation. And we know that this is copied from common law elements mentioned by Prosser and Keaton. Putting all of these elements together, the implication is that the basis of the 4 elements listed in this case is that it's the elements of Article 2176. Now you have a problem. Ilan ba talaga ang elements ng 2176? Ano ba talaga ang elements ng 2176? Ano ang memorizing ko for the exam? Yung 3 ba? Yung 3 pero mahaba. Ito 4 pero maiksi. Which one do I memorize? You can blame the Supreme Court for your confusion. In Lucas versus Tuanyo, which also characterized the court as the case as a medical negligence case, the court was more explicit. The court said, for lack of a specific law geared towards the type of negligence committed by members of the medical profession, such claim for damages is almost always anchored on the alleged violation of Article 2176 of the Civil Code. It also added that in medical negligence cases, also called medical malpractice suits, there exists a physician-patient relationship between the doctor and the victim. But just like any other proceeding for damages, not only did it limit it to medical negligence, all proceedings for damages. 4 essential elements: duty, breach, injury, and proximate causation. The Cayaw Lasam case, which we quoted earlier, cites as its basis Reyes versus Sisters of Mercy, which in turn cites Garcia Rueda versus Pascasio as basis for the 4 elements. The Lucas case cites Garcia Rueda directly Therefore, the root of the evil, or of both cases that identify Article 2176 as the basis of the 4 elements is Garcia Rueda. So obviously, we need to go there. The relevant portion of Garcia Rueda says this: a word on medical malpractice or negligence cases. In its simplest terms, the type of lawsuits which has been called medical malpractice, or more appropriately, medical negligence, is that type of claim which a victim has available to him or her to redress a wrong committed by a medical professional which has caused bodily harm. In order to successfully pursue such a claim, a patient must prove that the healthcare provider, in most cases a physician, either failed to do something which a reasonable, prudent healthcare provider would have done, or that he or she did something that a reasonably prudent provider would not have done, and that failure or action caused injury to the patient. Hence, there are 4 elements in medical negligence cases: duty, breach, injury, and proximate causation. That's what the court said in that case. It must be noted, first, that the court did not provide a basis when it listed the 4 elements. It can only be surmised that it used the 2 quoted paragraphs as basis. This is the court talking. This is something they quoted somewhere. So because there's no footnote here, we can assume that the basis for this statement are these 2 quoted paragraphs earlier. Now, it must be noted that the quoted paragraphs, if you read it again, does not justify in any way the 4 elements. It must also be noted that the case itself was not decided on the basis of these elements. The case was a civil action under Rule 65 of the Rules of Court, which you will memorize under Professor Avena, against the Ombudsman for its failure to uphold the public respondents for violation of Republic Act 3019. So ang layo, ano? The original complaint was one for homicide, for reckless imprudence. These facts, coupled with the nature of the source of these 2 paragraphs, do not make a case for a proper foundation for what seems to be a new cause of action, or cause for civil action for medical negligence cases. But since Garcia Rueda was decided in 1997, buhay na ba kayo nun? Okay, I don't feel that old. There have been a number of medical negligence cases, apart from Cayaw Lasam and Lucas, which list these 4 elements. In most of these cases, the court does not even identify any statutory basis. Wala lang, 4 elements, that's it. As if the mere listing of these 4 elements were enough. However, considering that the law of damages applicable to pesadelics, or the doctrine of proximate cause, is applied to some of these cases, it can be seen that the court considers these actions as at least analogous to a quasi-delict. Ano gagamitin nila for damages? To determine what damages will be awarded. So they are applying the rules on quasi-delict. It seems that despite its weak foundation, these elements of medical negligence have not just been accepted as part of Philippine tort law, but have even entered the realm of administrative and criminal law. So please inform your criminal law professors and Professor Calorta, whoever else teaches admin law. Because in Solidum versus People, the court said, an action upon medical negligence, whether criminal, civil, or administrative, calls for the plaintiff to prove by competent evidence each of the following 4 elements. And quoting similar, it's not exactly the same. Noticeably, the elements have changed somewhat, but are still the same in essence. Instead of proximate causation, what you have is reasonable, close, and causal connection. As you will learn later when we talk about proximate causation, that very well is proximate cause. What is required, instead of injury, the ponente used damages, which is wrong. So not only do we have medical negligence cases based on these 4 elements, based on some fictitious legal basis, it has even expanded into criminal and civil law, criminal and administrative law. So what was the basis of the court in Solidum versus People? This. The basis was a book by Martin Flam, Medical Negligence, Malpractice, and the Physician Defendant, Chapter 11, Legal Medicine, 4th edition. I was able to get the 3rd edition from the library. It's a medical book. So we now have a cause of action affecting criminal, civil, and administrative actions because some guy decided that this book is authoritative enough to establish an independent cause of action. It is intriguing how the court can consider this secondary source from a foreign jurisdiction for a legal medicine subject as basis for such an important rule which can affect litigation, civil, criminal, and administrative cases. The Solidum case involved a criminal action for reckless imprudence, resulting in serious physical injuries. The physician was acquitted due to the absence of expert testimony. As you will learn later in the course, there are certain kinds of cases, medical negligence cases included, which would require expert testimony to prove causation. The court in this case said, however, that we have to clarify that the acquittal of Dr. Solidum would not immediately exempt him from civil liability. But we cannot now find and declare him civilly liable because the circumstances that have been established here do not present the factual and legal basis for validity doing so. His acquittal did not derive only from reasonable doubt. There was really no firm and competent showing how the injury to Gerard had been caused. That meant that the manner of administration of the anesthesia by Dr. Solidum was not necessarily the cause of the hypoxia that caused the bradycardia experienced by Gerard. Consequently, to adjudge Dr. Solidum civilly liable would be to speculate on the cause of hypoxia. We are not allowed to do so, for civil liability must not rest on speculation, but on competent evidence. If you analyze what the court said there, if the reason for the acquittal in this criminal case is the absence of expert testimony, then doesn't that also result in absolution from civil liability? Why? Because the court earlier said that these same 4 elements apply, whether criminal, whether civil. You might argue, but sir, in criminal actions you need proof beyond reasonable doubt. That's true. But here, the court did not say there was not enough evidence. There was no evidence at all. So whether or not it's proof beyond reasonable doubt or preponderance of evidence, if you file a civil action using the same evidence, then you should lose. Now this is the duck. All right. Aside from medical negligence, 2176 is also used, or rather, elements, the 4 elements have been used for violations or illegal acts. Garcia versus Salvador is a case we already discussed in class. The person who was wrongly diagnosed with hepatitis, causing her father to suffer a heart attack. In this case, as you know, the court said that the elements of actionable conduct are the same 4 that we mentioned earlier. This is not a medical negligence case, although it involves misdiagnosis, because if you analyze the case closely, what the court held the clinic liable for were violations of the conduct of the business of providing or operating clinics. Another example of this is Ocean Builders versus Cubaco. In Garcia versus Salvador, at least there was Article 20, but you have these 4 elements. Or Ocean Builders versus Cubaco, you also know it's a violation of the labor code. You also have Garrido versus De La Paz, although I said I don't think you will find it. Even my RA, although she's very diligent in searching for cases, could not find Garrido versus De La Paz. Why? Because the court did not put it in scrap. Or because it's one of those cases now where the justices don't sign. It's only a notice signed by the clerk of court. Is that jurisprudence? It's a decision of the court, although it's not signed. But anyway, going back to Garrido, that's a legal method question, so I'll leave that to you. In Garrido versus De La Paz, the court said, 4 elements must concur in a suit for damages. Suit for damages. Not medical negligence, not torts, not psychedelics. Suit for damages. Which covers what? All 5 sources of obligation. Anyway, duty, breach, injury, proximate causation. And then it talks about medical negligence cases. The language of the court suggests that the 4 elements apply to any and all suits for damages, citing Lucas versus Tuanyo as its basis. The Garrido case was described by the court as one for torts and damages. Wow, cause of action pala ang torts and damages. Parang persons and family relations or obligations and contracts. It's a subject, Mr. Ponente, it's not a cause of action. But anyway, it involved a case filed by the wife of a man who allegedly suffered failing health, comatose, and eventual death as a result of the negligence of the hospital and its doctor. However, the complaint was eventually dismissed on procedural grounds. Hence, the subsequent discussion after the ruling on procedural grounds is obiter dictum. So that's why you can dismiss this case. But it's there. If someone finds it, it can be used. So we've talked about today some fundamental, some elementary dilemmas that you find in tort law. Ironically, the simplest things can baffle us the most. Definitions and elements of legal concepts are the building blocks of the more complex legal doctrines. But sometimes these building blocks are not clearly defined. Sometimes the court assumes too much, not realizing that these assumptions have serious legal implications. Perhaps in the haste to move on to complexity, little thought is given to the basic issues. But when the foundations of a legal regime is uncertain or unsound, the whole regime is at risk. The uncertainty can be blamed on the language employed in the civil code, like the second sentence of 2176, but more often, in the discussions of the court. The solution, therefore, is greater care in the words and phrases employed to define our legal rules, whether in the form of a code or jurisprudence. Those who construct our legal rules can ill afford to be negligent. In this lecture, we tried to figure out a way to reconcile the conflicts in the law and jurisprudence in torts. Except the last part. I still have to figure out how to resolve the problem on medical negligence and the 4 elements. I guess what we could say is that, well, it's built on a weak foundation and should not exist. But the problem is it exists. So what do we do? Maybe you can write about it in your SLR. But there's a difference between conflicting decisions and simply erroneous decisions. Certain decisions can be reconciled. Certain decisions are simply dead wrong and should be burned and, whatever else you can do with it. The discerning student of law should learn to tell the difference. Thank you very much for listening. And I hope you enjoy your pizza. Okay? Unless you have any questions, I will release you to gorge on whatever is outside to be eaten. No questions? Okay, I'll be the one to ask you questions in the finals na lang. Alright? Thank you for being here.
Hindi ko nililigpit ito. Gagamitin ni Hildo bukas eh. Hil.
Para saan?
Para legal.
Wala, bukas.
Ay, oo nga pala. Oo nga pala.